Hi everybody, another episode. I'm going to explain the IRAC to you now. It's recommended to watch Contract Law 1, 2 and 3. That's the general terms first and then go to the IRAC explained. Then you have a better order. Good luck. So actually, what is the IRAC method? The IRAC method is a method of legal analysis that is used internationally by all people in legal professions. You can analyze a case from a legal point of view. So instead of reading a story and wondering about what you can do for the people or what would be a fair solution, we're going to take a whole different approach. We're going to look at it from just a solely legal technical angle. First of all, we always determine what the legal issue is, and that is not like the problem people have. It's something else. It can be actually only two sentences. One is, did a binding contract form? And the other one is, who is liable for the damages? Those are the issues that we are working with. And why is it like that? Because those two issues, they combine with certain articles in the law. And that's our next step, rules. Which articles in the law, which rules are applicable in this case? Because you can imagine there's a whole lot of law, and when we read the case we have to determine which articles actually belong with this topic, with this case, because those are the only articles that you can use in a lawsuit. Those are the articles that fight against each other. So from the issue we get to the rules. After we have determined the issue and the rules, we go to the analysis, or well, the application, and we're going to apply the rules to both parties in our case. So we're going to see how would these rules work out for these parties. We don't judge. Even if somebody doesn't stand a chance with the article, we just make an analysis to see what possibly could come out of this case in a legal perspective. In the end, we reach a conclusion. Your conclusion gives you the answer to your issue. Because your issue, maybe you noticed, it's always a question. Did a binding contract form? Who is liable for the damages? The conclusion is an answer to that. If you read a verdict, it's like really the verdict of the judge, where he explains, this is my settlement, this is what I think should happen, and also explains why. We are also going to do that with cases of contract law. This is the entire IRAC in one page. This is everything you have to know for your test in one page. If you know this, you can do part 2 of the test. This is what you need to IRAC. As you can see, I made a blue part and a green part. That is actually random. It doesn't have any meaning, the color. I just wanted to show you the difference between step 1, the formation, where the issue is, did a binding contract form, and step 3, the termination, where we check who has an obligation to do something and who is liable for the damages if somebody didn't perform. So it's 2 different situations and 2 different issues. They each have their own rules. In week 4, we were busy with the blue part. Did a binding contract form. In week 5, we are going to look at the green part. So if you make your challenges in week 4 and week 5, you know that in week 4, you only stay in the blue part. Week 5, you stay in the green part. We're going to go to the blue part first and then the green part. And then it all comes together and you will know everything you have to know about any IRAC. So in week 4, we are going to analyze a case that has something to do with the formation of a contract. The blue rectangle. The issue at the formation is always, did a binding contract form? Because of course that is the first thing that we want to know if we have a case with a problem. Maybe people think they have a contract, but maybe they don't have a contract. We have to make sure there is a contract, because else we cannot apply the rules for contracting. We cannot apply the contract law if there is no contract. So the first thing we do is perform the triple check, like I already told you about. The triple check at the formation has the first question, offer acceptance. Is there an offer and acceptance? Second question, do our parties have legal capacity? Can they act in a legal contracting environment or not? Is somebody maybe a minor? Is somebody under guardianship? That's a deal breaker. Guardianship is really a deal breaker. A minor without permissions from the parents, also a deal breaker. If they offered or accepted something, it can never be legit, it can never be binding. And then we already went to the third question, did the will and declaration match? Remember, we will check if a person really wanted what he contracted about. And it can be that a person's will was influenced by either a threat or fraud, for example, from the other party, so coming from the outside. An external cause of defective will is also a deal breaker. There cannot be a binding contract if somebody put a gun to your head and you feel forced to enter into a contract. The other situation that we had there, that is really the most difficult one. I think that's also one of the most difficult situations in the entire contracting law. That is the will and declaration do not match, but it's caused by somebody's own mind. There is a problem inside somebody's head and it influences their will. For example, somebody's in a psychosis, it influences their will. They might enter into a contract that they else would never ever enter into. So triple check, we do that to confirm whether there is a contract or not. And in your IRAC, this is your starting point. Any case, it doesn't matter what it's about, you always start by looking, scanning the story for an offer and an acceptance, maybe a lead to a minor or person under guardianship, or something that makes you doubt the will and declaration were matching. This is the blue part of the IRAC, and we're going to perform this on a case. And I made it a little bit bigger so you can really see what is in here. We see on the left column the triple check, offer acceptance, legal capacity, will and declaration. In the middle we see the issue. The issue is always the same at the formation. The rules are not the same. With offer and acceptance, we have rule 6 to 17. And why is that? Rule 6 to 17 says any contract needs an offer and an acceptance to be binding. So that also means that if you miss an offer or an acceptance, there will not be a binding contract. The legal capacity. Article 332 says you need legal capacity to perform juridical acts, and that means you need legal capacity to play in the legal world, and a contract is a legal act. So if you don't have legal capacity, if you don't possess it, you cannot play. Minors, people under guardianship, they cannot act. If they do, their offer or acceptance is not binding, and then there is no contract. Third, will and declaration. We already learned that there is an external cause, fraud, threat. Somebody that forces you into a contract can never lead into a real binding contract. So 333, the main rule says if your will and declaration do not match, there will never be a contract. The only exception to that main rule is if somebody's will was influenced by his own mind. If the other person didn't notice and didn't have to notice something was maybe wrong, there will be a contract. So 333 says if your will and declaration do not match, there is no contract. 335 fixes that. It makes the contract binding, even though there was a defective will. And it does that by saying, listen, if we can't see it on the outside, it's not there. The person could justifiably trust the declaration of the other party. So It's a fixer. 335 is a fixer. It fixes a defective wheel, kind of. That is what we need to know to perform the IRAC in step 1 with the formation. It's better to do it. Kitchen studio case. There was once a woman and she suffered from manic depressions. In a way that really altered her reality so much that you could say her will was defective when she then would make a decision. The situation was that we had a Mr. A, he had a cooking studio. The materials, the equipment were a little bit older, he didn't feel like fixing it and he wanted to sell his studio. He had 2 employees, they were called Carl and David. Carl and David actually would have liked to buy that studio, but they didn't have the money to do so. But they knew that Mrs. B, they were acquaintances, and they also kind of knew that if they would encounter her in a manic state, that she would be really likely to invest money in their project. So they said to Mr. A, listen, we would like to buy a studio, but we have a friend that can also help us out, that maybe also wants to buy it. So they went to visit her. So out of the blue, in an afternoon, they rang her bell, they walked in and they were totally shocked to find her in a really chaotic, dirty, amazing mess. It's not a normal mess that people can have, but it was really outrageous. These 2 employees, Carl and David, were even so alarmed that they immediately made pictures and apped it to her daughter. What they also did is tell Mrs. B, like, oh, we would really like to buy a cooking studio. Do you want to be part of it? Or maybe you can be the owner of it. Are you interested in buying it? They took her to the studio. She looked at it. She was a very manic state, very energetic, very agitated, and on the spot she bought that studio for 75,000 euros. She then emptied her savings, her bank account, her old socks, anything she had, and she came up with 10,000 euros in cash. She had to pay 65,000 still, and you can already guess it, she didn't have that money. Very quickly afterwards, she had no food, she couldn't pay her rent, her kids were alarmed, they immediately went to her, and what they found is their mother in a manic episode, not taking her medicine and having made a very bad decision. She did not have that 65,000. She didn't really want a cooking studio. They called Mr. A and they said, listen, you took advantage of our mother. You should have seen something was wrong with her. But Mr. A said, hey, I'm not a doctor, I'm a businessman. I have her signature. She bought my place for 75,000 euros and I don't care how you do it, but you owe me 65,000. There was no talking, there was no negotiating, so this case went to court. And what do you do when you're a lawyer and you have to go to court? First of all, you make an IRAC, and that's really true, it's not a joke. If I have a case, I always first make an IRAC, because it's a very good way to estimate your chances, to see where your argument has to come from. Where is your best argument to win a case? How can you bend the case into your own client's way? So an IRAC is really a very necessary thing. I can imagine if you read a case like this and you have to make an IRAC, you're like, what do I have to do? Where do I start? Very simple. This is step by step. Do not think about the end. Only take the steps. You start always with a triple check. Do we see an offer and an acceptance here? Yes, we do. Do we see a minor here or somebody under guardianship? No, we don't. Maybe she could have been under guardianship, but then your case would tell you the person was under guardianship. Most people with a psychiatric illness are not under guardianship. So she also was not under guardianship. No minor, no guardianship. Then we have the third check. Will and declaration. Did will and declaration match in this case? Well, I doubt it. In a case like this, you should have doubt. Because We see that she suffers from manic depression. We see that she's in a really big mess. They still took her to a cooking studio. She buys a very expensive studio on the spot. We have to doubt if will and declaration matched. So, first check is okay. Second check is okay. Our third check is not okay. Something is irregular there. And that means we have to figure out whether or not this actually was a binding contract. We found our issue. Our issue is, did a binding contract form? The rule that belongs with this issue is 33 and 335, as you can also see in our overview. And that's what we take to our analysis, and then we will reach a conclusion. If now the story would have been a little bit different, there was nothing wrong with Mrs. B. She was just a nice, happy woman. There was no mess. She has the money. She really wants to buy the cooking studio. That would be a different situation. We still would have an offer and acceptance. We still would not have a minor or somebody under guardianship. And we would not have to doubt about will and declaration, because everything was in order. And if everything is in order, we go to the green part. But in this case, we stay in the blue part. So you do the triple check. If anything at a triple check, 1, 2 or 3 is not in order, if there's something wrong, you stop and you have your issue. Did a binding contract form? If everything is okay at a triple check, we proceed to the green part, and our issue will be who's liable for damages. That is how you start a case. It was a long story. And here we see step 2 and 3 of contracting together in a termination. I don't have a separate step 2. Step 2 is practically where you check emails and contracts and read things, but at the test we don't do that. Your story will be there, it will be clear, and you can derive the performances that people have to do from your case. So step 3, the termination. We perform the triple check. Let's say we perform the triple check, we go on, nothing was wrong, and we have a situation where parties either perform both 100%, the contract ends, there is no problem, but that's not funny on your test, of course, so I will make a case where there is a problem. Maybe somebody performed 100% and the other one didn't, or somebody performed 100% and the other one performed half. Then we have a problem. We cannot close this case, and somebody will be very unhappy because maybe they paid for something that they never received. So what do we have to figure out? Who is liable for the damages? That is how you can sum it up. And also, if you perform but the other one didn't, you have a right in the end to end the contract and of course get your damages refunded. You do not have to stay in a contract if the other person is not performing. And that is what we look at. Then we take this to our analysis. If everything is okay at a triple check, your issue will be who's liable for the damages, and you check out which articles you need. Probably 674 and 675 because they are really the winners. We will not go in book 7, so you can forget about book 7 now. We will not go there. And maybe you also want to end the contract. That is on the bottom, you're entitled to end the contract, and that is article 6 265. So that is what we do, and that was actually the whole IRAC. I made a few slides here for you to explain what you have to do and how you can write down the issue, the rules. That's what you see here. How to make an analysis. You write down obligation, performance, wants to apply this rule, wants it to result in, and you do that for both parties. If we would do that, for example, for the, let's see, the woman with the kitchen studio, her obligation would be to pay 65,000 euros still. What did she perform? 100% or less than 100%? She performed less than 100%. You don't have to indicate like it's 10% or 20 or 30. 100 or less, that's enough. So she didn't perform. She performed less. What rule would she like to use? She would like to use the rule 333 because it would result in her acceptance would not be binding because of her defective will, and there would never have been a contract. There is no contract if there is no acceptance, and that would mean that she would be entitled to get her 10,000 euros returned, and the situation would be like nothing ever happened. The studio owner though said, listen, what was my obligation? I had to hand over the studio. I did. I gave her the key. I performed 100%. I want to use rule either 674 because I think I had a contract with her and she has to do what she has to do. In case she has some kind of mental problem, I will use 335 because I justifiably could trust in what she said and what she did. I am no doctor, this woman was messy, but hey, who am I to judge her? She was very happy, she wanted to buy my studio, she gave me 10,000 euros and a signature. That's all I need, that's enough. And he wants it to result in the payment of the 65,000 euros. He wants the sale to be closed. He wants to to have the money. He wants a performance from the woman. He wants 100% performance from her because he says, listen, I performed, you also have to perform. I didn't know something was wrong with you, so I justifiably trusted you. You have to pay me. That's the application. And then the conclusion. Then you are actually like playing the judge in a case and you make a conclusion. Do you now have to come up like with the best solution in the case? No, this doesn't require a lot of creativity. You already sensed that probably. This is really a very systematic way of checking out how certain rules would lead to a certain conclusion. In this case, we can say Party A, the woman says that her will was defective, her acceptance was not binding, there was no contract. She wants her 10,000 euros returned. Party B, our kitchen studio owner, says, listen, I performed, I also want a performance from this woman, and I'm not a doctor, I didn't know something was wrong, so I'm entitled to 65,000 euros. We have two rules fighting. You see, it's not really parties that are fighting. We bring it down to two rules that are fighting. That is a legal analysis. You don't look at the parties. We don't really care the names. We don't care whether they cry or not. Maybe we do, but not really. So we just want to know what rule is applicable. And you can choose any rule you like in these cases. But let's say we start to look at the situation. The kitchen studio owner says, listen, I justifiably could trust her. Do we agree with that? Was there nothing that indicated something was really not really going well with the woman? The big mess, we have the pictures sent to her kids. You could say, listen, this should alarm you. You were not entitled to trust in her declaration. So I will not grant your 335. I go with 333, and that means the woman had a defective will, there cannot be a contract. That's your conclusion. 333 wins, there will not be a contract. Or you say, I agree with the kitchen studio owner, he is not a doctor, it was not up to him to judge if somebody has a mess in the house or not. He justifiably could trust in what she said. 335 wins, and that means that the defective will has been fixed, there was a contract, the woman has to pay 65,000 euros. Both are good. It's about the analysis and not the outcome. Another case, that's green and mean. We can also quickly go over that. Let's say you just opened a restaurant. You signed a contract with a bakery. The bakery was going to provide you with nice, fresh breads every morning. And you had a contract for 6 months. Every day they would deliver. But the first week everything goes wrong already. It's terrible because you just opened, you have a lot of customers and you cannot deliver. You have lost 1,500 euros of profit. You have to make extra costs to buy your bread elsewhere, and you had a lot of stress. You think, I do not like this. I don't want to be stuck to this. And the bakery says, yes, but you signed a contract. 6 months. Is that true? Do you have to stay in that contract? What can you do? And again, you know, when you hear this, you might think, where do I start? What is fair? I don't know. And it's okay to think that, but then you stop thinking and just apply your IRAC. It is like meditation, I will tell you. It's very zen. It's really soothing. All you have to do is start with a triple check. Do we see an offer acceptance? Yes! Signed a contract with the bakery, provide you with bread, 6 months. That is a contract, an offer acceptance. Do we find somebody under guardianship? No, we didn't. Is somebody a minor? No. Is somebody there with a defective will? We don't know because we don't even know these people. Correct. But do we see fraud or threat? No. Do we see somebody with a mental illness, a mental problem that could affect their will? No. What does it mean? Our triple check went well. There were no irregularities. That means we go off to the green part. In the green part, our question is, who has an obligation to do things? Who is liable for the damages? What is the rule? A contract. We apply it. You, what did you have to do? You have to pay the bakery. That's your performance. That's your obligation. You did. You performed 100%. What is the rule that you can use? Big giant 674 is on your side. You're very lucky with that. 674 says you performed, the other one also has to perform, and if they don't perform, they have to compensate all your damages. And that is the result that you desire. The bakery, on the other hand, had a performance duty, an obligation to deliver bread every morning for 6 months. Did they perform 100%? No, less than 100%. Is there a rule that they can use maybe against 674? Yes, tiny little 675. Maybe there was a force majeure that we don't know about. It's just a guess, but the only thing actually that they can use is 675. There is nothing else in our law book. The result of that would be that they are not liable. Now we check. We have found 674 against 675. You performed. You are entitled to apply 674. But was there a force majeure, we ask in our conclusion? Party B, the bakery, wants maybe to apply force majeure, but there was no force majeure in the story, and if it's not in a story, it's not there. There was no force majeure, so we put a big cross through 675. Then the only article we have left is 674, and that will be the winner in this case. And we follow what 674 says. It says, if you have a contract, you have to perform. If you don't perform, you need to compensate the damages. There you are. There you have your damages already. Furthermore, you want to end this contract because you don't want to be in it for the next 6 months. And 265, book 6, 265 gives you also the right to end the contract. So you can have it exactly your way. And in this case, it's also very fair. But fairness is not always a good measurement. So we just always make the IRAC step by step. Start with a triple check. If there's nothing wrong, you're in the green part and you will figure out who is liable for damages. And that was exactly the case here. Bakery is liable for damages, you will get the money, and also you can end the contract. Here is all my talking in a slide, and I also made like a document on Blackboard that says what do you have to do for the test and all the answers to the practice cases, then you can see all the IRACs for the cases that are in the PowerPoint. So they can help you to, get the hang of it. But always do it step by step. Start with a triple check, don't despair, just see where am I, what are the rules that belong with it. I make an application, always the same thing. What is the obligation? Did somebody perform? What is the rule that he wants to use, and what is the result that he can then get with that rule? Conclusion: party A wants something, party B wants something. What rule is the winner? And then based on that rule, what the rule says, you make a conclusion. And that's what you have to do. See?